All rise. Veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Thank you. Good afternoon to everybody. Would the court officer please call the case?
Thank you, Mr. President. The situation in the Democratic Republic of the Congo in the case of the Prosecutor versus Bosco Ntaganda. Case reference ICC 0104-0206. And for the record, we are in open session.
Thank you. My name is Howard Morrison and I'm the presiding judge in the appeals arising from the case of the prosecutor against Bosco Ntaganda. My fellow judges comprising the full bench in this appeal are Judge Hofmansky and Judge Luster Carmen Ebenes Carenza, who join me in the courtroom today, and Judge Solomé Balungi Bossa and Judge Chili Ibo Asuji, who join us through video link. May I ask the parties and participants to introduce themselves for the record, please, starting with the defense. Merci. Office of the Prosecutor, please.
Good afternoon, Your Honours. Appearing for the prosecution are myself, Helen Brady, Senior Appeals Counsel, and I'm here today with Senior Trial Lawyer Ms. Nicole Sampson and Appeals Counsels Ms. Meritstelle Reggae and Mr. Matthew Cross and Mr. Matteo Costi and Mr. George Mangwanya. Thank you very much.
Thank you. And now the legal representative of victims, please.
Merci, Monsieur le Président. Les anciens enfants soldats sont représentés par moi-même, Sarah Pellet, conseil au bureau du Conseil public pour les victimes.
Thank you. Now I note that Mr. Antaganda is also present in the courtroom.
Excuse me, Mr. President. Can I introduce myself, please? Good afternoon, Mr. President, Your Honors. The victims of the attacks are represented today by myself, Dmitry Supron, counsel at the Office of Public Counsel for Victims. Thank you.
Thank you. Now today the Appeals Chamber is delivering two judgments. The first judgment in relation to the appeals of Mr. Bosco Ntaganda and the prosecutor against the decision of Trial Chamber 6 of the 8th of July 2019, which convicted him of war crimes and crimes against humanity. And the second one in relation to the appeal of Mr. Ntaganda against the sentencing decision of Trial Chamber 6 of the 7th of November 2019, which sentenced him to a joint sentence of 30 years imprisonment. I will refer to these decisions as the conviction decision and the sentencing decision. I shall first address the appeals against the conviction decision, starting with the procedural background. On the 8th of July 2019, the trial chamber rendered the conviction decision in which it found Mr. Ntaganda guilty of 5 counts of crimes against humanity, murder and attempted murder, rape, sexual slavery, persecution, forcible transfer and deportation, and 13 counts of war crimes, murder and attempted murder, intentionally directing attacks against civilians, rape, sexual slavery, pillage, ordering the displacement of the civilian population, conscripting and enlisting children under the age of 15 into an armed group and using them to participate actively in hostilities, intentionally directing attacks against protected objects, and destroying the adversary's property. The trial chamber found Mr. Ntaganda was guilty as an indirect co-perpetrator for all crimes charged and as a direct perpetrator for one act of murder, constituting a crime against humanity and a war crime, as well as an underlying act of persecution as a crime against humanity. Today's judgment by the Appeals Chamber addresses the appeals against the conviction decision of both Mr. Ntaganda and the prosecutor. In his appeal brief, Mr. Ntaganda raises 15 grounds of appeals, challenging the fairness of the proceedings and arguing that the trial chamber committed several errors of law, fact, and procedure. In her appeal brief, the prosecutor raises 2 grounds of appeal, challenging the trial chamber's interpretation of the term attack in Article 8.2e4 of the statute, intentionally directing attacks against protected objects. In relation to some of his challenges, Mr. Antaganda requests that the Appeals Chamber order a new trial or a permanent stay of proceedings, and in relation to others, that it reverse his conviction. The prosecutor asks the Appeals Chamber to enter additional and limited findings of fact and to convict Mr. Ntaganda for 2 additional incidents. In the first ground of appeal, Mr. Ntaganda challenges Judge Kuniko Ozaki's judicial independence under Article 42 of the statute. The Appeals Chamber considers that the legal framework of the court does not provide for any appeal against a decision taken by an absolute majority of the judges under Article 40 of the statute to the Appeals Chamber. While Judge Ibo Asuji does not concur with this reasoning, he concurs with the Appeal Chamber's ultimate outcome. The Appeals Chamber emphasizes that judicial independence of judges is at the core of the court's legal framework to safeguard the general integrity of the proceedings before the court. It is for this reason that the statute provides for a specific mechanism in Article 40 which focuses on this subject matter and sets out the procedure to follow should an issue about the independence of a judge arise. This procedure has been followed in the present case. The Appeals Chamber considers, however, that an appellant may still raise on appeal matters affecting the fairness of the proceedings. In that regard, the Appeals Chamber notes that Article 81(1)(b)(4) of the statute expressly provides the convicted person or the prosecutor on his or her behalf with the possibility to raise a ground that affects the fairness or reliability of the proceedings or decision. In the present case, Mr. Ntaganda neither presents arguments challenging the fairness or reliability of the conviction decision under that provision, and therefore the Appeals Chamber dismisses the first ground of appeal. Judge Ibanez, while agreeing with the outcome of the Appeals Chamber, disagrees with its reasoning insofar as it concludes that the issue of judicial independence is not appealable before the Appeals Chamber. In her view, Mr. Antaganda has a right to raise any issue which may have affected the fairness of the proceedings pursuant to Article 81(1)(b)(4) of the statute. However, Judge Ibanez finds that Mr. Ntaganda has failed to show a material effect of the lack of independence of Judge Ozaki. Judge Ibo Asuji is of the view that the Appeals Chamber is not precluded from considering the issue of Judge Ozaki's independence just because it was already determined by the plenary of judges. However, after having examined Mr. Ntaganda's arguments, Judge Ibo Asuji would still confirm the conclusion of the plenary of judges that on the independence of Judge Ozaki and reject the ground of appeal. In his second ground of appeal, Mr. Ntaganda submits that his right to a fair trial was violated because 1. The trial chamber resorted in an excessive manner to ex parte material, and 2. The prosecutor failed to disclose Mr. Ntaganda's non-privileged conversations from the detention centre to which she had gained access, and the trial chamber did not take measures to mitigate the prejudice that resulted from these disclosure violations. 3, that the trial chamber failed to suspend the proceedings prior to the resolution of the no case to answer appeal, and 4, that the trial chamber prioritised expeditiousness at the expense of Mr. Ntaganda's right to a fair hearing. Regarding the first challenge, the appeals chamber finds that while resort to ex parte proceedings should be limited, in the present case, Mr. Antaganda received sufficient notice of the content of the relevant ex parte submissions. Furthermore, the trial chamber took adequate measures to counterbalance potential prejudice. Regarding the second challenge, the appeals chamber finds no error in the trial chamber's reliance on the risk of prejudice to the prosecutor's investigation, as well as on the protection of witnesses, as reasons for withholding parts of the relevant material from disclosure. The appeals chamber notes that in the trial chamber's assessment, prejudice to Mr. Ntaganda was limited, and that it took measures to protect the rights of Mr. Ntaganda. Regarding the third challenge, the appeals chamber finds that Mr. Ntaganda has not demonstrated that the trial chamber erred in not suspending the proceedings prior to the resolution of his appeal against the decision denying leave to file his no case to answer motion. With respect to the fourth challenge, the appeals chamber finds that Mr. Ntaganda has not demonstrated that the trial chamber prioritised expeditiousness at the expense of his right to a fair hearing. Therefore, the appeals chamber rejects the second ground of appeal. Under the third ground of his appeal, Mr. Ntaganda submits that the trial chamber erred in convicting him of criminal acts that were outside the scope of the charges. The appeals chamber finds that it is not necessarily inconsistent with Article 74(2) of the statute for the prosecutor to formulate and for the pre-trial chamber to confirm charges that do not consist of an exhaustive list of individual criminal acts. The appeals chamber finds that the criminal acts which Mr. Ntaganda challenges under this ground of appeal were included in the confirmed charges, and that therefore the trial chamber did not err in convicting Mr. Ntaganda of those acts, as they do not exceed the facts and circumstances described in the charges. The appeals chamber therefore rejects the third ground of appeal. In his fourth and fifth grounds of appeal, Mr. Ntaganda challenges the trial chamber's finding that an attack had been directed against a civilian population pursuant to, or in furtherance of, an organisational policy. In particular, under the fourth ground of appeal, Mr. Ntaganda disputes the findings that the UPC FPLC had a policy to attack and chase away Lendu civilians, as well as those who were perceived as non-Aturians. He argues that the trial chamber erred in its assessment of the evidence relied upon to establish this policy. For reasons that are fully set out in the judgment, and following careful review of the trial chamber's evidentiary assessment, the appeals chamber rejects this challenge and finds that the trial chamber's overall conclusion concerning the existence of an organisational policy is reasonable. Mr. Antaganda also argues that the trial chamber erred in finding that the UPC FPLC was an organisation prior to the 9th of August 2002. However, he fails to identify any material impact of the alleged error, and accordingly this argument is dismissed in limine. Under the fifth ground of appeal, Mr. Ntaganda challenges the trial chamber's finding that an attack was directed against a civilian population. In particular, he alleges that the trial chamber failed to find that a civilian population was the primary object of the attack and did not accord sufficient weight to the legitimate purpose of the 6 military operations during which the attack was committed. He also argues that the trial chamber wrongly limited its analysis of the evidence to 6 military operations and failed to consider relevant evidence regarding other UPC, FPLC operations. Finally, he submits that it was an error to find that orders to attack civilians were issued. For reasons that are fully set out in its judgment, the Appeals Chamber finds that Article 7 of the statute requires a finding that the attack was directed against any civilian population and does not require a separate finding that the civilian population was the primary object of the attack. This means no more than that the attack targeted the civilian population. It need not be established that the main aim or object of the irrelevant acts was to attack civilians. An attack directed against a civilian population may also serve other objectives or motives. The question of whether an attack was directed against a civilian population is essentially a factual issue that may be assessed by considering inter alia the means and method used in the course of the attack, the status of the victims, their number, the discriminatory nature of the attack, the nature of the crimes committed in its course, the resistance to the assailants at the time, and the extent to which the attacking force may be said to have complied or attempted to comply with the precautionary requirements of the laws of war. Taking into account the foregoing, the Appeals Chamber finds that the Trial Chamber properly directed itself as to the relevant considerations and reasonably concluded that the attack was directed against a civilian population. The Appeals Chamber also concurs with the Trial Chamber's view that the requirement that the acts form part of a course of conduct indicates that Article 7 of the statute is meant to cover a series or overall flow of events, as opposed to a mere aggregate of random or isolated acts. The Appeals Chamber considers that this does not require an analysis of the totality of the activities and military operations of a state or organisation to establish that there was a course of conduct involving the multiple commission of acts referred to in Article 7.1, or that the attack targeted a civilian population. After a careful review of the Trial Chamber's findings and the evidence relied upon, the Appeals Chamber concludes that its conclusions that orders to attack civilians had been issued and that an attack against the civilian population took place was reasonable. On the basis of the foregoing, the Appeals Chamber rejects Mr. Ntaganda's 4th and 5th grounds of appeal. Judge Ibanez and Judge Ibo Asuji have set out their views on aspects of the legal requirements for the contextual elements of crimes against humanity in separate opinions. Under the 6th ground of appeal, Mr. Ntaganda argues that territorial control is a condition of ordering displacement of the civilian population under Article 8(2)(e)(8) of the statute, and that the Trial Chamber therefore erred by relying on orders issued during the conduct of hostilities, but prior to the relevant territory falling under the control of the UPC, FPLC, to found the conviction for this crime. The Appeals Chamber notes that there is no explicit requirement in Article 8(2)(e)(8) of the statute, the elements of crimes, Article 17 of the Additional Protocol 2, or customary international humanitarian law, that to order the displacement of the civilian population in the context of a non-international armed conflict the perpetrator must be in occupation of or exercise territorial control over the relevant area. While the Appeals Chamber accepts Mr. Ntaganda's argument that Article 49 of the Fourth Geneva Convention may provide useful guidance in interpreting Article 17 of Additional Protocol 2 to the extent that similar language is used, the fundamental differences between the two provisions mean that the requirements for one cannot simply be transposed into the other. In view of these differences, the Appeals Chamber cannot accept Mr. Ntaganda's arguments that Article 8(2)(e)(8 of the statute should be interpreted as requiring territorial control in accordance with the requirements of Article 49 of the Fourth Geneva Convention. With respect to Mr. Ntaganda's argument that civilians must be within the perpetrator's power and control in order to give effect to an order to displace, and that therefore territorial control is a requirement under Article 8(2)(e)(8 of the statute, the Appeals Chamber considers that whether the person is in a position to give an effect to an order to displace the civilian population is a question of fact that depends primarily on the position occupied by the accused person and his or her duties and responsibilities, including the ability to ensure compliance with his or her orders. Given that the trial chamber's analysis of this element focused on the perpetrator's positions of authority and power to ensure compliance with their orders, the Appeals Chamber can find no error in the approach. In view of the foregoing, the Appeals Chamber rejects Mr. Ntaganda's argument that territorial control is a condition of ordering displacement as a war crime under Article 8(2)(e)(8 of the statute, and the sixth ground of appeal is therefore rejected. Under the seventh ground of appeal, Mr. Ntaganda challenges the trial chamber's assessment of his own testimony, regarding that it rejected his testimony when it contradicted prosecution evidence and thus reversed the burden of proof. The Appeals Chamber considers that the credibility, reliability, and weight of defence evidence falls to be assessed in the same manner as evidence presented by the prosecutor. It finds that the trial chamber properly assessed the credibility of Mr. Antaganda's testimony in light of the evidentiary record as a whole and resolved inconsistencies in that evidence. There is no indication that in doing so it reversed the burden of proof. Mr. Ntaganda also argues that the trial chamber should have considered the fact that he testified before other defence witnesses in his favour. The Appeals Chamber finds that the trial chamber has discretion in how it considers the timing of the accused testimony, and that the argument that it should have considered the timing of Mr. Ntaganda's testimony favourably is unjustified. Also under the seventh ground of appeal, Mr. Ntaganda argues that the trial chamber wrongly rejected the evidence of one of his former bodyguards, D0017, in its entirety because it found that it lacked any credibility. The Appeals Chamber is not persuaded by this argument. It considers that the trial chamber weighed D0017's evidence against the other evidence on the record and rejected it on a reasoned basis. Finally, under this ground, Mr. Antaganda argues that the trial chamber wrongly relied on the prior recorded statements of two witnesses to enter convictions against him. The majority of the Appeals Chamber considers that there is no legal impediment to prior recorded testimony admitted pursuant to Rule 68(2) of the rules being relied upon to establish individual criminal acts in circumstances in which they are not the direct acts of the accused. However, prior recorded testimony must not form the sole or decisive basis for the conviction for a particular crime as such. Other instances of similar criminal acts must be established on the basis of oral testimony, so that the right of the accused to challenge the evidence grounding his conviction for that crime is not prejudiced. In relation to the prior recorded statements that were the subject of Mr. Ntaganda's complaint, the appeal chamber considers that they were not the sole or decisive basis for the trial chamber to enter convictions against Mr. Ntaganda, and therefore the trial chamber rejects the seventh ground of appeal. Judge Ibo Asuji is unable to concur with the majority's determinations regarding the use of prior recorded statements for the purposes of conviction, and considers that the trial chamber erred in relying on unsworn statements that speak to the acts and conducts of those through whom Mr. Antaganda was found to have committed the crimes in question. Under the eighth ground of appeal, Mr. Antaganda challenges the trial chamber's finding in relation to 6 discrete events during which crimes were committed by the UPC FPLC. Mr. Ntaganda argues that the trial chamber's assessment of the evidence with regard to those 6 events was tainted by its reliance on the uncorroborated testimony of accomplice witnesses, namely P768, P963 and P17. I will not provide a detailed summary of the appeals chamber's assessment of this evidence. For present purposes, it suffices to say that the trial chamber was aware of the general standards applicable to the assessment of witnesses' credibility, including those concerning accomplice witnesses, and provided sufficient reasoning to support its reliance on the evidence of these witnesses. It is the view that the trial chamber provided a reasonable assessment of the evidence of P768, P963 and P17. Accordingly, the eighth ground of appeal is rejected. I now come to the 9th and 12th grounds of appeal. Under the 9th, 10th, 11th and 12th grounds of appeal, Mr. Ntaganda submits that the trial chamber erred in finding that individuals under the age of 15 years were used as escorts, were enlisted in the UP FPLC and actively participated in the hostilities, that it was unreasonable for the trial chamber to find that incidents of rape and sexual enslavement occurred, or that Mr. Ntaganda knew about these incidents based upon the testimony of P0758, P0883, and the testimony of a number of witnesses regarding the rape of a person named Maeve, and that the trial chamber erred in inferring that he intended and knew that individuals under the age of 15 would be or were being recruited or conscripted into the UP FPLC and thereafter used to participate actively in hostilities. For reasons that are fully set out in the judgment, the appeals chamber finds that the trial chamber provided a reasonable assessment of the evidence of the relevant witnesses when making the impugned findings regarding the use of individuals under the age of 15 within the UPC FPLC, and Mr. Ntaganda's knowledge of incidents of rape and sexual enslavement of individuals under the age of 15, including the rape of Maeve, and about the recruitment and conscription of individuals under the age of 15 into the UPC FPLC. On the basis of the foregoing, the appeals chamber rejects Mr. Ntaganda's 9th, 10th, 11th and 12th grounds of appeal. The remaining grounds of appeal relate to the mode of responsibility of indirect co-perpetration. Both Judge Ibo Asuji and I entertain considerable reservations concerning the application and scope of the trial chamber's judgment in respect of Mr. Ntaganda's criminal responsibility in utilising the theories of indirect co-perpetration and control of the crime. They are set out in our separate opinions. In our view, the issues and scope of the application of indirect co-perpetration and control of the crime theories are not settled in international criminal law. My reservations do not lead me to conclude that the conviction decision needs to be set aside because of the limits of appellate review and because the trial chamber was expressly following the earlier jurisprudence of the court, which was apparent to the appellant. On the other hand, Judge Ibo Asuji's reservations lead him to conclude that Mr. Ntaganda's conviction should be set aside insofar as it is based on the theory of indirect co-perpetration. He would, however, confirm the conviction for those crimes that he considers Mr. Ntaganda to have directly committed. Judge Ibanez also writes separately in support of the theory of indirect co-perpetration and control of the crime. In her view, indirect co-perpetration is a mode of liability enshrined in Article 25(3)(a) of the Rome Statute that constitutes one of the most appropriate tools with the type of mass criminality associated with international crimes under the jurisdiction of this court. Under the 13th ground of appeal, Mr. Antaganda raises a number of arguments aimed at demonstrating that the trial chamber erred in its approach to the common plan and the crimes committed in implementation of this plan. The appeals chamber is of the view that, contrary to Mr. Ntaganda's argument, the trial chamber's finding that the co-perpetrators meant the destruction and disintegration of the Lendu community was not an expansion of the common plan charged by the prosecutor. Regarding the evidence upon which the trial chamber relied to make findings in relation to the meeting that took place in Kampala in June 2002, Mr. Ntaganda has not demonstrated that this evidence is contradictory and insufficient to sustain a finding. The appeals chamber also finds that Mr. Ntaganda has not demonstrated an error in the trial chamber's reliance on the evidence of that meeting to establish that the co-perpetrators agreed in a common plan to drive out the Lendu from the localities targeted during the course of their military campaign against the RCD KML. Therefore, the appeals chamber considers that the trial chamber was not required to infer the existence of a common plan from evidence of subsequent concerted action of the co-perpetrators as argued by Mr. Ntaganda, nor was it an error for it to rely upon the evidence of commission of crime by individual soldiers. Regarding the trial chamber's findings on crimes committed in the implementation of the common plan, the appeals chamber considered these findings to be sufficiently detailed and specific to the crimes in question. It notes that, contrary to Mr. Ntaganda's argument, the findings relate to more than just the commission of crimes and include meetings, specific orders, and instructions to the troops. The appeal chamber therefore considers that it was reasonable for the trial chamber to infer from these findings that the co-perpetrators meant for these crimes to be committed by virtue of the common plan. Mr. Ntaganda also argues that the trial chamber erred in convicting him for the actions of Hema civilians in Mongbowalu. The appeals chamber finds that it is reasonable for the trial chamber to have concluded on the basis of the evidence of orders to the Hema civilians and their joint operation with the UP FPLC soldiers that the Hema civilians functioned as a tool in the hands of the co-perpetrators and that their will had become irrelevant. The appeals chamber therefore rejects the 13th ground of appeal. Under the 14th ground of appeal, Mr. Ntaganda argues that the trial chamber erred in finding that he possessed the requisite mens rea as an indirect co-perpetrator for crimes committed during the first operation. He submits that 1. The trial chamber erred in fact by relying on 2 alleged directives given by him to enter a finding about his mens rea. 2. None of the other factors relied upon by the trial chamber to infer his intent for the crimes charged, either collectively or individually, sustain its finding of mens rea. And 3. In inferring the existence of a fact upon which a conviction relies, the trial chamber failed to consider the reasonable possibility of other available conclusions and associated relevant evidence. After a careful review of the evidence underlying each of the trial chamber's factual findings, supporting the findings on Mr. Ntaganda's mens rea in the first operation, the appeals chamber concludes that none of the appellant's challenges renders the trial chamber's determination on his knowledge and intent of the crimes unreasonable. In the 15th ground of appeal, Mr. Antaganda alleges 1. Legal errors in the trial chamber's application of the law on indirect co-perpetration. 2. Errors in the assessment of his contribution to, and mens rea for, the crimes committed during the second operation. 3. Errors in the trial chamber's factual findings on his direct contributions to the second operation, arguing that his de minimis contributions to the second operation reveal no awareness that he was exercising control over or making an essential contribution to the crimes of the second operation. And 4. Errors in the trial chamber's reliance on the testimony of P0055 that Mr. Ntaganda was contemporaneously informed of the Kobu massacres and expressed approval of that event. The appeals chamber considers that, consistent with the principle of causation, an accused essential contribution must be to the crime for which he or she is responsible. However, a contribution of a co-perpetrator, which on its face is not directly to a specific crime, but to the implementation of the common plan more generally, may still suffice. The appeals chamber finds that for indirect co-perpetration, the knowledge component of mens rea includes an awareness on the part of the co-perpetrator of the factual circumstances that enabled him or her, together with other co-perpetrators, to jointly exercise control over the crime, and Mr. Ntaganda fails to identify an error on the facts of this case. In the light of the foregoing, Mr. Ntaganda shows no error in the trial chamber's application of the law on indirect co-perpetration, and his arguments are therefore rejected. In relation to Mr. Ntaganda's argument that the trial chamber was bound to analyse his responsibility in respect of both operations separately, the appeal chamber recalls that the decisive consideration for co-perpetration is whether Mr. Ntaganda's contribution as a whole amounted to an essential contribution to the crimes within the framework of a common plan, and determines that the trial chamber was not required to analyse Mr. Ntaganda's essential contribution with respect to the specific crimes charged in each operation. Therefore, the trial chamber was not required to assess Mr. Ntaganda's mens rea in respect of the specific criminal acts committed in each operation. In order to find him criminally responsible as a co-perpetrator for specific criminal acts of murder or rape that took place on particular dates and in particular locations, it need not be established that Mr. Ntaganda was aware of the details of these events, including whether and which specific acts had been committed. Rather, what must be established is that he possessed the requisite mens rea with respect to the crimes as such, in the sense of murder, rape, persecution, pillage, etc., committed in the implementation of the common plan. The Appeals Chamber considers that the Trial Chamber did not err in finding that the first and second operations were part of the same military campaign and constituted a logical succession of events. Given that both operations were an integral part of the common plan and were interrelated, the Trial Chamber was correct to assess Mr. Ntaganda's role in a holistic way rather than conduct a separate analysis of his contributions and mens rea for the first and second operations respectively. In relation to Mr. Ntaganda's challenges to the Trial Chamber's factual assessment of his essential contribution to the implementation of the common plan, the Appeals Chamber recalls that a determination of whether an alleged co-perpetrator exercised control over the crimes necessarily depends on a holistic assessment of all the relevant facts and evidence. It considers that, on the basis of the findings and evidence relied upon, the Trial Chamber's conclusions in the present case were reasonable. Finally, the Appeals Chamber finds that the Trial Chamber's conclusions that Mr. Ntaganda meant for the troops deployed during the second operation to engage in the conduct and cause the consequences required for the commission of the crimes was reasonable, and accordingly the 14th and 15th grounds of appeal are rejected. I now turn to the prosecutor's appeal. The prosecutor raises two grounds of appeal, under which she argues that the Trial Chamber erred in not considering that the term attack in Article 8.2e(4) of the statute has a special meaning, and that an attack for the purpose of this provision is not limited to the conduct of hostilities. This is in relation to Count 17, under which Mr. Antaganda was charged with attacking protected objects as a war crime, including in relation to looting at the hospital in Mongboalu and breaking into the church at Seo. The Trial Chamber concluded that it would not consider these two events under Count 17 as they did not constitute attacks. The Appeals Chamber finds by a majority, Judge Ibanez dissenting, that the prosecutor's appeal should be rejected. Judge Hofmansky and I find that the term attack used in Article 8.2e(4) of the statute means combat action, and that the Trial Chamber did not err by not applying a different definition of attack. Judge Palungi Bossa considers that it was unacceptable for the Trial Chamber to find that the conduct of hostilities ceased after the assault in Mongboalu for reasons set out in her separate opinion. She declines to overturn Mr. Anda's acquittal for the charge of attacking protected objects as a war crime against the hospital in Mongboalu and the church in Seo. Judge Ibo Asuji is of the view that the kind of attack that the Rome Statute forbids can occur outside the course of active hostilities, and he does not accept the Trial Chamber's findings in this respect. For reasons set out in his partly concurring opinion, he declines to overturn the Trial Chamber's dispositif on this particular matter. Judge Ibanez Carranza partly agrees with Judge Palungi Bossa and Judge Ibo Asuji that the Trial Chamber erred in the interpretation of the term attack in Article 8.2e(4) of the statute, and finds that the term attack includes the preparation, the carrying out of combat action, and the immediate aftermath thereof. Judge Ibanez would grant the prosecutor's appeal and would reverse the Trial Chamber's findings in this respect. The Appeals Chamber confirms by a majority the conviction decision and rejects the appeals lodged by Mr. Ntaganda and the prosecutor. But I now turn to the separate opinion of Judge Ibanez Carranza. In her separate opinion, Judge Ibanez addresses two fundamental legal concepts, that, as illustrated in Mr. Antaganda's submissions made both in the conviction and sentencing appeals proceedings, amount to misrepresentations that require further clarification. The aim of Judge Ibanez's separate opinion is to strengthen the Appeals Chamber's judgment and to assist in the better understanding of the criminal law applied at the court for this and future cases, both before this court and other national and international jurisdictions. In this she discusses the contextual elements of crimes against humanity, in particular the requirement that widespread or systematic attack directed against any civilian population be carried out pursuant to or in furtherance of an organisational policy, and the meaning and scope of indirect co-perpetration, including through an organised power apparatus as a mode of liability provided for in the statute. In relation to the first issue, Judge Ibanez considers that the focus of the determination of whether an organisation qualifies as such within the meaning of Article 7 of the statute ought to be on those features that would allow it to carry out a widespread or systematic attack against any civilian population. Furthermore, to establish the existence of a policy to commit an attack within the meaning of Article 7 of the statute, it is unnecessary to prove that such policy was underpinned by any sort of ideology or motivation. In Judge Ibanez's view, it is possible that the state or organisation is motivated by a legitimate aim, but the means through which it seeks to achieve it are criminal, resulting in widespread or systematic attacks against the civilian population. She considers that when interpreted in the light of the object and purpose of the statute, the policy requirement ought to be understood as imposing a minimum threshold that aims at excluding ordinary crimes from the realm of crimes against humanity. Moreover, Judge Ibanez is of the view that widespread or systematic attack for the purposes of crimes against humanity amounts to a campaign of serious human rights violations that manifests in the multiple commission of acts referred to in Article 7.1 of the statute. In relation to the facts of this case, Judge Ibanez considers that the UP-FPLC was a well-organised structure, capable of planning, conceiving and implementing an organisational policy to attack and chase away the Lendu civilians, as well as those who were perceived as non-Iturians. Judge Ibanez is of the view that while the aim of the UP-FPLC to put an end to the power exercised by the RCD-KML in the territory of Ituri may have been illegitimate, the means by which this objective was sought to be achieved crystallized into a policy, the implementation of which resulted in widespread and systematic attack against the civilian population during both the first and second operations. In her opinion, the fact that the UP-FPLC may have conducted other military operations in relation to which no evidence of the commission of crimes against civilians was presented is irrelevant to the trial chamber's finding that the attack comprised of multiple acts referred to in Article 7.1 of the statute, which were directed against the Lendu civilians. With respect to the second issue, Judge Ibanez finds that indirect co-perpetration is an integrated mode of liability encompassed in Article 25.3a of the Rome Statute that combines the constitutive elements of co-perpetration and indirect perpetration and is therefore compatible with the principle of legality and the rights of the accused. She considers that the control of the crime serves as the objective distinguishing criterion to differentiate perpetration in all its modalities from other forms of individual criminal responsibility under Article 25.3 and Article 28 of the statute. Furthermore, Judge Ibanez considers that indirect perpetration through an organised power apparatus is one modality of commission through another person as provided in Article 25.3a of the statute. By virtue of his or her hierarchical position, within the hierarchically established organization and its automatic functioning ensured by the replaceable nature of its members, the indirect perpetrator exercises functional control over the crimes and retains the power to frustrate their commission. Judge Ibanez is of the view that due to the nature of the crimes under the jurisdiction of the court that generally involve large-scale and mass criminality, indirect co-perpetration constitutes an appropriate tool to deal with such atrocities and to investigate, prosecute, and convict those bearing the highest responsibility. Judge Ibanez considers that regarding the mental element in the context of indirect co-perpetration through an organized power apparatus, the accused persons must be aware of and intend 1. To participate in a common plan that involves the commission of crimes. 2. A coordinated realization of the objective elements of the crime. 3. The fact that implementing their common plan will result in the realization of the objective elements of the crime, or be aware that the realization of the objective elements will be a consequence of their acts in the ordinary course of events. And 4. The existence of an organized power structure, hierarchically controlled by them, that functions automatically and is composed of replaceable elements at the base willing to implement the common plan and to commit crimes as a result. In her view, unlike in cases of direct perpetration, where the perpetrator fulfills the concrete elements of the crime in person, there is no need for the indirect co-perpetrator to be aware of the particularities of each criminal incident, because these are committed through another person, and, therefore, they are different modes of liability. In this case, Judge Ibanez finds that the UP FPLC was an organized power apparatus, given that it was hierarchically organized and composed of replaceable members willing to carry out the criminal plan of the organization. Throughout the period relevant to the charges, Mr. Ntaganda exercised, by virtue of his hierarchical position, control over the automatic functioning of the organization, which led to compliance with the instructions, directives, and orders by the replaceable direct perpetrators on the ground. In Judge Ibanez's view, the facts of the case show that Mr. Antaganda was aware and intended the commission of crimes that were indirectly perpetrated by UP FPLC forces and HEMA civilians. She considers, therefore, that he was properly charged and convicted as an indirect co-perpetrator through an organized power apparatus. I'm now turning to appeal against sentence, but before I do so, I am made aware that the defence lead counsel did not turn on his computer, and therefore the names that he introduced are not read into the record, and it might be therefore appropriate to repeat the appearance before the delivery of any further parts of the judgment.
Monsieur le Président, les personnes que j'ai mentionnées tout à l'heure, il s'agissait de Maître Laurence Hortas-Laberge, Mademoiselle Daria Machetti, Maître Mélissa Beaulieu-Lucier, Maître Didas Nirinkoya, Maître Kate Gibson, par voie de vidéoconférence, Mademoiselle Anine Gali et moi-même, Stéphane Bourgon. Merci, Monsieur le Président.
Thank you. Mr. Burgoyne, it wouldn't be the first time that people have failed to either switch on or switch off their computer at the appropriate time. I now turn to the appeal against sentence and the background of the appeal proceedings. On the 7th of November 2019, the trial chamber sentenced Mr. Antaganda for the 5 counts of crimes against humanity and the 13 counts of war crimes for which he was convicted. Mr. Antaganda received a joint sentence of 30 years of imprisonment, with a deduction for the time spent in detention from the 22nd of March 2013 onwards. In his appeal against the sentencing decision, Mr. Ntaganda raises 12 grounds of appeal, in which he alleges that the trial chamber either abused its discretion and or committed errors of law and fact in relation to its findings on his degree of participation in and knowledge of the crimes committed during the first and second operations, as well as findings related to various aggravating and mitigating circumstances. In this respect, he requests that the Appeals Chamber reverse the trial chamber's alleged errors and substantially reduce the related individual sentences and the joint sentence. Mr. Ntaganda's grounds of appeal and the Appeal Chamber's findings in this regard are summarised as follows. In his first ground of appeal, Mr. Ntaganda submits that the trial chamber erred in law and in fact by not making a distinction between his degree of participation in the crimes committed during the first operation and those committed in the second operation. The Appeals Chamber is not persuaded by Mr. Ntaganda's argument that the trial chamber erred in refusing to consider his physical proximity to and knowledge of the specifics of the crimes committed as demonstrating a lesser degree of participation in the second operation. In its view, it is in the nature of indirect perpetration as a form of criminal responsibility that physical proximity to the commission of crimes and knowledge of the specific details of how the crimes are committed are not required in order to find that an individual is responsible as a principal perpetrator. Although the Appeal Chamber accepts that these factors may be indicative of the degree of participation of an individual in certain circumstances, it is not convinced that the absence of these factors must be taken into account as generally pointing to a lesser degree of participation. In the present case, the Appeals Chamber considers that the trial chamber properly assessed Mr. Ntaganda's degree of participation by evaluating the role he played in relation to the commission of the crimes. Accordingly, the Appeals Chamber concludes that the trial chamber did not err in refusing to consider his physical proximity to and knowledge of the specifics of the crimes committed as demonstrating a lesser degree of participation in the second operation. Likewise, the Appeals Chamber considers that his argument that the trial chamber assessed his participation in the two operations as though it was a single phenomenon is unfounded. In the Appeals Chamber's view, the trial chamber carried out an assessment of the in concreto gravity of his culpable conduct for each crime. In his second round of appeal, Mr. Antaganda challenges the trial chamber's assessment of his degree of participation in and knowledge of the crime of rape of civilians under counts 4 and 5. The Appeal Chamber notes that the trial chamber carried out a concrete assessment of his degree of participation in the crimes. It is recalled that some of the rapes that occurred during the first operations took place at the apartment camp, which was Mr. Ntaganda's base. Moreover, it took into account his presence at the camp, his awareness that women were brought there, and the fact that he brought women there himself. In the Appeals Chamber's view, his knowledge was therefore clearly established. Furthermore, on the basis of the trial chamber's further analysis, it concluded that Mr. Ntaganda's degree of culpability was substantial regarding the rapes committed against civilians during both operations. Consequently, the Appeal Chambers find no error in the trial chamber's approach. In his third round of appeal, Mr. Ntaganda submits that the trial chamber failed to address his lack of knowledge or concrete participation in the sexual enslavement of civilians and in the rape and sexual slavery of 3 individuals under the age of 15. With respect to the crimes committed against civilians during the second operation, the Appeals Chamber considers that the trial chamber carried out a concrete assessment of his degree of participation in the crimes. Based upon the trial chamber's findings, the Appeal Chamber concludes that Mr. Ntaganda's knowledge of the crimes committed against the victims was established by virtue of the agreement made between the co-perpetrators to implement the common plan. As for the crimes against individuals under the age of 15, the Appeals Chamber finds no error in the Trial Chamber's conclusion that while his degree of intent was lower than for the sexual crimes against civilians, his degree of involvement and participation in their commission was significant. In his fourth ground of appeal, Mr. Ntaganda submits that the Trial Chamber erred by finding that his participation in the second operation murders, including the Kobu massacre, was enhanced by 1. His failure to punish Commander Salumu Malenda for the Kobu massacre, and 2. His purported post facto approval of the Kobu massacre and other murders committed by Mr. Malenda's troops. The Appeals Chamber notes that in reaching its conclusion that the participation intent regarding the murders and attempted murders in the second operation was substantial, the Trial Chamber did not find that Mr. Ntaganda's participation in or intent regarding the separation operation was enhanced by his failure to punish Salumu Malenda or his expression of the approval of the Kobu murders, as Mr. Ntaganda suggests. Rather, in reaching its conclusion, the Trial Chamber considered a number of factors, including the fact that Mr. Ntaganda took part in the relevant planning of this operation and that he remained in contact with the commanders in the field. As to the argument that the Trial Chamber erred in law by relying upon his expression of post facto approval of the Kobu massacres, the Appeals Chamber considers that this argument conflates the notion of intent with the evidentiary considerations that may be relevant to establishing it. The Trial Chamber took into account the fact that Mr. Ntaganda expressed approval of the murders when he was informed of what happened in conjunction with other findings relevant to establishing his mens rea. Accordingly, the Appeals Chamber finds no error in the Trial Chamber's assessment of Mr. Ntaganda's failure to punish Mr. Malenda or his expression of approval of the Kobu murders for the purposes of sentencing. In his fifth ground of appeal, Mr. Antaganda challenges the Trial Chamber's assessment of an aggravating circumstance relating to the deaths of 7 individuals that resulted from the crime of intentionally directing attacks against civilians. The Appeals Chamber notes that under Article 8(2)(e)(1) of the elements, actual harm or death is not a required element for the crime of intentionally directing attacks against civilians to be fulfilled. Hence, where actual harm or death does arise as a consequence of the unlawful attacks on civilians, a trial chamber is not precluded from considering that actual harm or death in its determination of an appropriate sentence, provided that it is sufficiently linked to the crime of intentionally directing attacks against civilians, was objectively foreseeable by the convicted person, and the findings related to this consequence were established beyond reasonable doubt. Accordingly, the Appeals Chamber finds no error in the Trial Chamber's approach and assessment. In his sixth ground of appeal, Mr. Ntaganda argues that by imposing an individual sentence of 30 years for the crime of persecution, which was equal to the highest sentence imposed for the underlying crime of murder, the Trial Chamber impermissibly engaged in double counting. In his view, the only appropriate sentence for persecution in these circumstances was 0, given the overlapping conduct and the related discriminatory dimension between the crimes underlying counts 1 to 5, 7 to 8, 11 to 13, and 17 to 18, and the crime of persecution. The Appeals Chamber considers that Mr. Ntaganda's argument ignores the two-step sentencing process prescribed under Article 78(3) of the statute. The Appeals Chamber considers that the calculation of an individual sentence necessarily entails an assessment of all the circumstances relevant to a particular crime. If the circumstances relevant to more than one individual sentence were to be excluded from the calculation of any one of those individual sentences, the true culpability of a convicted person for a particular crime would be unclear. Consequently, the Appeals Chamber finds that the Trial Chamber did not err in imposing an individual sentence for persecution by taking into account the same underlying conduct and the discriminatory nature of such conduct that was also considered when settling individual sentences for the crimes underlying counts 1 to 5, 7 to 8, 8 to 13, and 17 to 18. Moreover, the Appeals Chamber considers that a sentence amounting to 0 would have effectively ignored Mr. Ntaganda's conviction for the crime of persecution and therefore resulted in an error of law. We go on to the 7th to 12th grounds of appeal. In these grounds of appeal, Mr. Ntaganda challenges the Trial Chamber's assessment of mitigating circumstances. In his 7th ground of appeal, he submits that the Trial Chamber erred in law or misrepresented the facts in considering that saving the lives of 64 enemy combatants was not a mitigating factor. In his view, his actions represented a substantial humanitarian act, deserving of acknowledgement and weight in mitigation. However, given that the Trial Chamber found Mr. Ntaganda's actions to have been aimed at using the captured soldiers for the benefit of the common plan, the Appeals Chamber considers that regardless of how many individuals Mr. Ntaganda was alleged to have saved, or how forcibly he had to intervene to save these lives, his ultimate motive was necessarily diminish the value of his actions. As such, his actions cannot objectively amount to a substantial humanitarian act. In his 8th ground of appeal, Mr. Ntaganda disputes the Trial Chamber's rejection of his traumatic experience in the Rwandan genocide in mitigation of his sentence. The Appeals Chamber notes that notwithstanding the fact that the Trial Chamber expressly acknowledged the suffering and discrimination that Mr. Ntaganda had endured as a result of experience in the genocide, it was reasonable for the Trial Chamber to find that his personal experience could not diminish his culpability, given his criminal conduct and the gravity of his crimes. In the 9th ground of appeal, Mr. Ntaganda submits that the Trial Chamber erred in failing to enter findings on and accord-weighted mitigation to 1. His alleged protection of Lendu civilians in Mandro in June 2002, his protection of other civilians by deploying troops, and 3. His punishment of crimes against civilians. In his 10th ground of appeal, Mr. Ntaganda challenges the weight accorded by the Trial Chamber to his alleged genuine and concrete contribution to peace and reconciliation with the Lendu community, as well as to the demobilization and integration of the UPC FPLC members into the armed forces of the DRC. For reasons that are fully set out in the judgment, the Appeal Chamber notes the Trial Chamber's comprehensive findings on these issues and concludes that the Trial Chamber's assessment of the evidence was reasonable and based upon the correct application of the balance of probabilities standard of proof and its discretionary power. In his 11th ground of appeal, Mr. Ntaganda challenges the Trial Chamber's assessment of his cooperative behaviour with the court during trial as a mitigating factor. The Appeal Chamber notes that good behaviour and cooperation with the court during a trial is expected of any accused person. As such, good behaviour and cooperation cannot, in and of itself, constitute a factor in mitigation of sentence. However, as correctly stated by the Trial Chamber, such behaviour may be considered to be a mitigating factor if it's found to be exceptional in nature. In rejecting this factor as mitigating, the Appeals Chamber finds that the Trial Chamber's holistic assessment of his behaviour was reasonable and finds no merit in his argument the Trial Chamber misappreciated the facts when concluding that his conduct during the trial was not exceptional. In his 12th ground of appeal, Mr. Ntaganda challenges the trial chamber's assessment of his efforts to assist fellow detainees who could be described as struggling with custody as a mitigating factor. The appeals chamber notes that in finding Mr. Ntaganda's actions to be commendable, the trial chamber was fully aware of the facts and circumstances surrounding his actions and expressed its appreciation for his conduct. The trial chamber also clearly assigned weight to this factor in mitigation. However, in balancing this factor against the gravity and aggravating circumstances established for the crimes for which Mr. Antaganda was convicted, it found this factor to be too limited to have an impact on his individual and overall sentences. The appeals chamber finds no error with the trial chamber's exercise of its discretion in this respect. Having rejected Mr. Ntaganda's grounds of appeal in their entirety, the appeal chamber hereby confirms the trial chamber's sentencing judgment. This brings me to the end of the summary of the appeals chamber's judgment. I reiterate, of course, that this summary is not determinative, for that one has to look at the full judgment. I would like to thank all registry staff who assisted in enabling this hearing and to proceed in a partially virtual manner, and to the interpreters for their skill and dedication. This hearing is adjourned.
All rise. Veuillez vous lever.